Hello, everybody. How are we doing? Hope everybody's doing well under these circumstances. And today I just wanted to review and tie up a lot of our readings that we've had in these past 2 weeks. So as we move into the final month of our semester, this will be kind of the foundation for where we're headed towards that final exam. The chapter in the textbook on civil rights. And I want to illustrate today how it's linked up to Kelly Lytle Hernandez's piece on abolition, on our piece on dehumanization, on Kevin Johnson's Sweet Home Alabama, and also to our documentary Prejudice and Pride, and to think about how the contention or the struggle for civil rights is a constant one. Or as Angela Davis has noted famously, that freedom is a constant struggle in her latest collection of essays. So what I want to point to is this notion of the law. Right now we exist in this moment of pandemic. Policies are being implemented by states, by localities, across all 50 states. None of them are so uniform, and some are. But what you see here on this slide are some uniform systems that were legal. And people in those societies were socialized in a way that they were told that they had to follow the law. So a question that we confront every day: do we follow all laws, even when we know inside intuitively that something may be wrong or immoral or unethical? So we see here apartheid. Apartheid was a system that was separation by race in South Africa that was legal up until 1994, when it was with the leadership of Nelson Mandela that was finally undone. Or the Holocaust in Nazi Germany that led to the culmination, the obliteration of over 6 million humans. That was legal. Here in the United States, slavery was a system that was legal. And if you were a black slave and you wanted to be free, you were breaking the law. And the process of dispossession, of taking someone's land and claiming it your own because you had more power, or what we call the system of settler colonialism, that was legal. That was codified in law. And if your land was being taken, you had to obey that process. For us, we set here in motion the Treaty of Guadalupe Hidalgo. Was a legal document that settled the takeover of these lands here, right? So we've covered that a bit in our previous exam. And as we're thinking about the law and notions of justice, they have to do more with who has the power. So the law is a matter simply of power, not necessarily of justice. And that's how I really want us to confront this history that we're really reading, but also our present moment and how we're thinking about these notions of justice or everyday policies that are being implemented here around us and how they affect you, your families, our community, and our society as a whole. So to distinguish between civil liberties, which was in chapter 4, what are civil liberties? Many of us in society kind of conflate civil liberties with civil rights, but what is the distinction? So civil liberties, simply put, are constitutional freedoms that Americans enjoy and to which the government may not encroach upon. So this is the idea that we as citizens, as human beings, have protections that the government may not take away. And those are found in the Bill of Rights, the first 10 amendments to our Constitution. So these Bill of Rights were not initially part of the U.S. Constitution, and these were issues that those folks debated in the initial Constitution, but were not ratified until a year later, after the original Constitution was ratified in 1789. Now, in contrast to civil rights, simply put, are protections against unequal treatment that the government guarantees to all groups, to all who exist in the United States, deserve civil rights. In Kevin Johnson's piece, Kevin Johnson, again, is the dean of the law school at UC Davis, And he argues in his piece, Sweet Home Alabama, that we all read, that immigrant rights are civil rights. And how does he make that claim? Well, he illustrates through his data and his historical argument that immigrant rights are fundamentally civil rights, not only because we see those violations happening to a particular population, those who we see as undocumented, but also U.S.-born Latinos and Latinas, right? We'll talk more about that in the subsequent lecture. So discrimination by law is defined as, you've read, it means de jure. This is a Latin term that means by law and by regulation or policy, discrimination is the law. Now, when you have discrimination simply on an individual level or by groups or organizations, or exists just by fact, that again emerges from the Latin term de facto. So what we saw, for example, here in the United States, discrimination by law, we had up until 1954, until the Supreme Court ruled in the famous Brown versus Board of Education case that discrimination in education was no more. That began the legal unraveling of discrimination. But discrimination in the present, in 2020, exists simply de facto or by fact. So if you go to Kevin Johnson's page 22, this is his central argument, where he says the civil rights implications for immigrants and the Latinx population raised by state immigration laws are in many respects similar to the civil rights issues raised by Jim Crow for African Americans. So in this essay, he's linking not only the historical relevance of the geography that he's really examining in the state of Alabama, but he's also looking at the practices that these two populations have faced. In 1963, you see this cartoon here, in 1963 being denied education to African Americans, and in 2011 to Latinos through law. And so as we move to this contention where Alabama is making the case that it is their states' rights, and this has been one of the central arguments that states have used to discriminate. So we see here on this map, you have Georgia, Mississippi, Alabama. States in the South have used this concept or this legal declaration that they find in the Bill of Rights, ironically, in the 10th Amendment, delegates that states have the right to assert their sovereignty. So those rights that are not defined clearly by the federal government over the state has some sovereignty to create their own laws. But on immigration, this is an issue that is pretty clear. This belongs in the hands of Congress. But yet that does not stop states from producing their own anti-immigrant laws. And a lot of them you see here, Georgia, Alabama, Mississippi, the infamous Senate Bill 1070 that we covered in class in the state of Arizona. So we see this continuity between slavery, Jim Crow, mass incarceration, to this notion of now reasonable suspicion. And this is where race plays a big role for Latinx populations in Alabama and in these other states. And this was upheld by the Supreme Court, as Kevin Johnson discussed. After Senate Bill 1070 in Arizona was cast as unconstitutional by the Supreme Court, they still upheld one provision, and that is the reasonable suspicion clause. So allowing the police on the street to become immigration enforcement officers if they had reasonable suspicion that somebody is in the territory undocumented. So how does one come to that conclusion if you are a police officer on the street? So this centralizes how race operates in our society, right? And here is another similarity here. The Bull Connor, who was the head of of the police force and really unleashed his police force on African Americans in their fight for civil rights. And the modern day Bull, what we call the modern day Bull Connor, Sheriff Joe Arpaio, who was indicted by the Justice Department under President Obama, who was criminally prosecuted and condemned to sentence, but immediately, again, found guilty of violating the civil rights of Latinos in Arizona, but was immediately pardoned by his friend Trump. So what we have here is how the state operates and condones and accepts the violations of civil rights if they serve an ideological purpose. And we know how this operated, civil rights violations to Latinx populations. And in their book, historians Francisco Valderrama and Raymond Rodriguez show that in the 1930s, in their book titled Decade of Betrayal, Mexican Repatriation in the 1930s, this was during a similar period that we're about to really delve deep into, right? The economic depression of after 1929. So in this moment, again, casting out those workers who were seen as essential from one moment are now seen as disposable in another moment, and therefore targeted by law to be removed from the territory. One issue with this was, out of the almost 1 million Mexicans who were deported back to Mexico, about 600,000 of them have been cataloged in the present were U.S. citizens. So you're removing U.S. citizens from their country of origin, a clear violation of the Constitution and one's civil rights. So we may think that this is something of a bygone era. We still have the removal and the targeting of U.S. citizens, as shown by Kevin Johnson today, and also shown by multiple research reports here in 2020, where U.S.-born persons of Latinx origin are targeted, policed, detained, and not only detained as for violating a law, but for violating the sovereignty of the territory of the United States, because they are seen as being undocumented. Right? So race, again, where Natalia Molina pointed how these racial scripts really shape the consciousness of the police officers, right? So the police force, their job is to follow the law. They are following the law, and through the obedience of not whether it is right or wrong, but the implementation of the law, right? So even if one police officer says, well, it may be wrong to target a population based on their race, they still have to follow the orders to keep their job and to receive their daily paycheck. And this is precisely what happened when police officers in Los Angeles rounded up Mexicans, Mexican Americans, placed them in trains, and forcefully put them in their cars or on buses and trains and back to the country of Mexico, where the irony is many of them had not even been to Mexico in their lifetime. But also operating historically, and which was constitutionally upheld, I wanted to highlight this another Supreme Court case, Prigg versus Pennsylvania in 1842. And this kind of highlights for us now what we see as maybe being an absurd use of the law, but this was constitutionally protected, and the Supreme Court at the time upheld. So this ruling held that the U.S. Constitution, federal laws, and slaveholders' property rights superseded the authority of states seeking to protect runaway slaves and punish slave catchers. So even when states attempted to protect the freedom of those slaves who had fled those southern slavocracy and come up to northern free states, the federal government's law to protect the property rights of white men, meaning their property were black men and women and children, was to be respected by other states. So in New York, who sought to protect runaway slaves, by law they had to return that property, right? So think about that, the absurdity of that. If any of you own pets, I have many pets in my home.